Welcome back to Your Money and Your Life on this Saturday afternoon, and a very big welcome to one of our usual regular financial planners, Claire Mackay from Quantum Financial. Claire, good to see you. Thanks for joining us again this week.
Pleasure, David.
You've had a good week?
Awesome week.
Plenty of clients coming in and
Lots of wonderful clients doing lots of interesting things.
yeah, just give us what's bothering them at the moment. What's the most common question you get from your clients at the moment?
At the moment, it's about the super changes coming in next year and making sure that they're ready for that.
Right.
But also, it's also about just making sure that they're on track for their early retirement and their wonderful holidays.
Yep.
All the wonderful things that everyone wants to do with the end of working.
Yep.
We're all about talking about that and making sure that the money's going to be there to do it.
Yep. All right, now today we're going to focus in on inheritance as well, and so basically estate planning, isn't it? And it's one of those things that we all ignore. It's one of those taboo subjects, isn't it? That we don't like to think that we're going to die, and that will that we were forced to do 25 years ago is still relevant. What are some of the good tips for planning properly for your estate?
I think the key thing is that you're right. People want to put their head in the sand, but these documents and these thought processes and the strategies around it is not for you. It's for the people you care about, and it's making life easier for them, so you have the documentation in place, but also that you're not leaving a tip for the tax man and structuring it appropriately for your family.
Okay, let's kick off with that financial side. What are the tax traps that people make in terms of their estate planning, and how costly can it be for people?
Well, the big one is superannuation. So if your superannuation goes through your estate, there could be a top-up tax, whereas if it goes directly to your spouse or your dependent children, then there's no top-up tax because it's considered to be going to your immediate family and people who are dependent on you. So superannuation doesn't have to go through your will. It can go directly to your spouse, depending on how you've structured your pensions.
So, and that's that beneficiary form, isn't it, with your
Yes.
superannuation, which a lot of people think, I don't really need to fill that in because it will be part of my estate. Well, you should be filling it in.
Absolutely, absolutely. You want to see a name there that you actually care about, because if there's blank, then you're relying on the trustees of your fund to make sure that it goes either to your estate or someone who claims for it.
Okay, so that's really important. What other discussions should you be having when planning for your will?
Well, who do you want to be receiving your estate, and making sure that you're aware that if you're choosing not to leave people something, that there's a good reason for it, and maybe that your wishes may not be actually upheld. So would there be a likelihood of a challenge to your estate when you're no longer around? Understanding the personalities involved, but also then thinking about if you're giving these people you care about a wonderful opportunity, giving them the opportunities to structure it in a way that helps them and their families.
So, are you saying you should talk about your estate with your kids and your partner? Because what a lot of older Australians do is they don't talk about their estate, their will, do they? And because they see it as a bit of a power base for them
Absolutely.
going forward,
Absolutely.
which is such a shame and can create so many problems, can't it?
Well, the counter is that if people know how much you're worth, then there might be some untoward behaviour.
Right.
So there is a balance between being open and honest and having discussions, but also, looking after your own affairs and not encouraging people to act not in the best way possible in the lead up to it. So they'll eventually get it. They don't need to necessarily know all the details. We certainly say that for couples, they should be talking amongst themselves and talking to their advisors and making sure the documentation is in place. Whether they choose to engage their children and other family members in that discussion is entirely up to them, and it depends on the dynamics of the family.
It's so tricky, isn't it? I once, probably the financial story over my whole career that I've written that has had the most reaction was when I did a story about if you're an adult child, how to approach your parents about their will and estate and talk about it and not appear to be a gold digger.
Absolutely.
Well, the reaction I got from it was just enormous. And people say, well, I've tried to do it with my parents. They refused to do it. And there were some silly situations that came about because of a friend of ours whose parents died. And there were two kids, son and a younger sister, younger daughter. So they left the entire estate to the older son.
Oh, golly.
And said, and you will look after your sister. And of course, you go, What the hell does that mean?
You've got 30-something years of frustrations of sibling rivalry and all sorts of other things
exactly
in
right.
there. Yeah.
So that's the thing, isn't it? Because it's not just the financial side, it's looking after the emotional side of your family at a time of grief.
Absolutely. And I think there's a couple of things that I always say to my clients is you want to look after the people you care about. You don't know who is going to be in their ear when the decisions are being made. You know, daughters-in-law, son-in-laws that you may like, may have left, new partners that you don't know.
And they're in input.
Exactly.
Yep.
So you want to be able to, I always think it's important that when money's involved, you'd like to think everyone behaves in their best version of themselves, but they may not, and it may be through all sorts of other reasons. So having the structures in place, having the documentation in place, getting advice about what is the best for your family means that you know that you've done everything you can.
And constantly updating it because family circumstances change, don't they? As you say, you know, in-laws can come into the family and often you want to protect your direct descendant or divorce.
Yes.
What issues come up then?
So there's the ways that money go to various family members can be structured in ways such that it may not be part of a divorce settlement. I mean, the family courts are fairly broad in what they can access. But again, structures you put in place in your documentation may give benefits to your children and their children.
Right. How do you protect it? And I'm coming through all these experiences of families in the past. Okay, you have an adult child who's married to someone that you don't think is going to be long term and you want to separate it out and you don't want it to become part of their estate as well. Are there structures you can put in place for that?
The most obvious one is a testamentary trust. So your money goes into your will, your estate, but it doesn't go directly to your child. It goes into what's called a testamentary trust created out of your will, and the beneficiaries are your child, their children, and not necessarily the spouse, if you depending on how you write it. Like I said, the family courts can sort of look into all sorts of things, but it creates a little bit of a barrier that's a little bit wider, a little bit taller, and it gives the flexibility to your children that they otherwise wouldn't have.
Yep. How should a will be put together? Is it necessary to go to a lawyer? There are these online wills and everything like that at the moment. Can you write it yourself?
Well, I think the first thing you should always do is write down in your words what you want to happen.
Yep.
Because once you get the lawyers involved, the fees go up and the legal jargon continues. So first get a clear understanding of what you want to happen, and then depending on the complexity, you can either use a do-it-yourself will kit. I would always recommend that you then take that to a lawyer to get it reviewed. But if it's a complex will and there's going to be challenges and the like, I would certainly get legal advice. Okay,
all right. And that, again, depends on the... how can I put it? Uniqueness of your family.
Everyone is unique.
We had a question from Donna that's been sent in through the email, david@ymyl.com.au. Send your questions through. Donna says, we've got 2 children aged 18 and 22. They currently own their cars and rent, but don't have much in the way of investments or other assets. Is it too early for them to be considering a will? Is it something you'd recommend?
Everyone should have a will who has a bank account. If nothing else, if something were to happen to either of these 2 lovely children, then the grief and the legal structures you have to go through, a simple will makes things a little bit simple for the family that you're leaving behind. So absolutely encourage everyone once they turn 18 to at least write a simple will.
Because there's this myth that says, oh, you've got to have relationship, you've got to have dependence, you've got to have assets and debt before you even need to think about a will. You're saying at least do a simple one when you turn 18.
A bank account, your super fund, these are things that all need the documentation in place. Otherwise, the system is a little bit more complex and unnecessarily so.
Okay, all right. Great advice there. Thank you, Claire. Good to see you as usual.
Lovely.
Claire Mackay there from Quantum Financial.